My lord, please tell me what should I call you? Hello everyone,
I'm Rahul Devdhar.
I am Prasanna Naidu and you are listening to the Right Views podcast. So, why are we saying is this? Because recently in the Supreme Court of India, there was a matter going on and a law student, if I am not wrong, a law student addressed the court as Your Honor. Okay, which is a usual practice, not only in the Supreme Court, but also in high courts and other various subordinate courts too. So, usually it is court, the judge is referred to as or addressed as Your Honor, Your Lordship, My Lord. And in subordinate courts, like the lower courts, magistrate courts, and all small causes and all, they are also addressed as Sir or, yeah, these are the usual terms which are used. But this time, Justice Bobde, who is also the Chief Justice of India, he objected to this address. What he said was, "This is not the Supreme Court of United States, okay, or some other like you are in a Supreme Court of India. So here we don't refer to judges as Your Honor." Or he said this is an incorrect term. Okay, so the law student said that okay, so I apologize for that and I'll address you as Your Lordship or my Lord. So he replied back saying that whatever, but don't use incorrect terms. But here is the controversy, or some disagreements or agreements. In 2006, there was a notification which discussed the use of my lord and your lordship, and it prescribed your honor or honorable court as an acceptable way for addressing the Supreme Court and High Court, and sir in subordinate courts and tribunals. Okay, so which is quite opposite to how Mr. Bobde reacted. But from what I know, what I have read recently, after this resolution, there was a resolution passed where Mr. Bobde had amended this. Do you have any idea about these rules, Rahul sir?
These rules have been existent since the Bar Council resolution. That is correct. But this particular matter, it's a little different. And whenever we refer to things like, let's say, matters being reported in Supreme Court, you have to take everything with a grain of salt. I haven't found an exact reporting of these matters. Now, clearly, if you have been before a judge, this is basically, the judge ragging the junior advocate and the law student. So this form of sort of banter. It's like it happens all the time in the court. Now, there are two things. What happens if a junior lawyer steps up before the judge of the High Court or the Supreme Court? They usually ask whether this junior lawyer has read the matter, and they try to gauge whether he has really appreciated the matter in detail or not. The second thing what happens is whenever there is a party in person, the same thing happens to a party in person, because many times party in person usually they are emotional and they take up the time of the court, and then nothing comes out of it. They are not prepared with the legal process of the matter in the court.
By party in person, you are saying that any litigant or any person who has filed a case, he appears in person without engaging any advocate, right?
Correct, exactly. But here in this case, this was a party in person who was a lawyer. I mean, a student of law. So I think he was a law student or she was a law student, and that's why I think judges have taken some liberty with the banter. I think one can ignore such things in a normal proceedings. And Justice Bobde, given that he was a judge in the Mumbai High Court and some proceedings I have attended before him, he is a light-hearted fellow. He is not a particularly strict person. What I think he was doing is just ragging the would-be advocate. But having said that, there is this process or this procedure of addressing the court is absolutely part of what is called the practice of court, which he has put it in the order. If this is not the practice of the court. And practice of the court usually is basically sort of a ritualistic thing which continues from, I don't know, whenever the courts have been established, and it follows it, or it takes its cue from the British courts. So that's why that lordship and things continue. Now there are lots of things which have changed, and they have a lot of problems, because when the court system was established, there were no female judges. So the thing was that now we have female judges, or since we have had female judges. Now, how do you address a female judge? Do you call her in Britain, it's the lord and my lord and my lady. That's how you address a lord. Now here, how do you address my lord and my lady? It becomes a little different. Okay, the connotation becomes different. So people started using lordships and ladyships, and that kind of thing has continued. It has its merit. Some lawyers called both genders with lordships, because lord as a gender neutral something term for a person who is a judge. So whoever comes, they address as lordship. So that female judges don't mind, and they take it in a different, they take it without giving undue importance to that. But this procedure, it is to a certain degree important, because it creates some sort of a sanity in the court process. Okay, sometimes it helps the court process, and it creates faster. It helps move things faster. So there are these shortcuts which have been created. Now that is fine, but there is a big problem in India, that you have no substantive justice. So if you have lots of delays and this procedure is followed, procedure is like a, it's more, in a sense, it's a frill or it's an icing on a cake. But in India, the cake is missing. So you can't simply give the icing. Now this becomes a problem. And when it becomes particularly acute in case when the justice is not being served. So the person who is before a Supreme Court or a High Court, he's already spent 20, 25, 30 years in litigation, not getting a proper justice. And when he comes before the court, he would appreciate if the court really doesn't engage in frills and focus on more substantive issue, rather than focusing on these little bits of whether I addressed him as my lord or your honor or sir. That ideally should become immaterial, and that is what he expects or she expects after 25, 30 years of litigation. And at such time, when you get an adjournment because of something like a procedural lapse, and as silly lapse as what we have seen, like you're not called you're not addressed the court appropriately. Now that you can say it is cruel. In this case, it was a ragging. The Supreme Court ragging the junior advocate. So you can just bypass this particular instant. But in general, if you insist on this, can be not just addressing the court as a procedure, but it can be something. It can be as trivial as that I don't have the papers today, my lord, and then it goes for a 6-month date. Now I have seen, and you have also seen, matters get postponed by 3 months, 6 months, just because the opponent advocate or the court manager or the court itself doesn't have the papers. And that's the thing, the person is pursuing this matter for 25 years, 25 years, through various courts, going up, to the High Court sends it back, you go back to the lower court, conduct the proceeding again, you haven't received the money, all sorts of questions and pain areas are there. And then this happens. So the person becomes really disheartened, and his confidence in the legal system erodes. And that is more problematic, if you ask me, rather than simply, it's a matter of adjournment because the lawyer was not prepared. In this case, that's true. He was not prepared with the matter. He had not studied the matter. In particular case of PIL, I particularly advise that whenever you're filing a PIL, you have to do a lot of research. PIL people file as if it's a hobby. Just go there. Why is there? My sky has become so many clouds. So then they'll take photo from 1987. Skies in November were clear. Today in November skies are more cloudy. PIL. Nothing court can do, but you have to find proper research, back the petition properly, and courts are ready to entertain you. In fact, my point is court interfere in the legal process a little too much for my comfort. But on that is on one side where they are interfering in the law making side, but on the other side where it is their role, where it is their purview to grant complete and a proper justice to the litigant, to both litigants in fact, that doesn't happen. So you focus on your area first, and then you insist on others performing and addressing you as your lordship, because it's cruel if you don't have substantive justice and you insist on procedural compliance. That is why this article has resonated more with the public rather than just the case of being my lord and your honor.
Yeah, actually, in an article also, I read that a senior advocate of the Supreme Court said that this must not be a problem. Like, we have grown up seeing generations of lawyers, he said, addressing Supreme Court and High Court judges as my lords. There are senior advocates in Supreme Court who address judges as sir, which is usually not the case. Like, sir is said only at the magistrate levels in courts, but not in a High Court or Supreme Court. But this is also been followed by some senior advocates in Supreme Court, and it works. I mean, it's fine.
Yeah, it is fine. It's mostly, courts, you leave aside this case. So that's what I'm saying. At this particular case is a multiple issues are involved. And in general, the courts don't mind so long as the main matter is proceeding with more substance. So courts are also not, let's not blame the courts here as if they are not doing their jobs. I think they are overworked. That is separate issue altogether. But what you have to understand is that these courts also are, you have to imagine the case, a scenario where from 11 o'clock to 5 o'clock with just 1 hour break, you are listening to people with no coherent statements, who make no coherent statements, who go into all sorts of details saying, Modi said this, Modi said that. Your case is about getting water connection in your cooperative housing society. What is Modi got to do with this? But they will say all sorts of things and they waste the time of the court. Sometimes, it's an emotional matter. So, really speaking, a father is seeking custody of his child, a mother is seeking custody of her child. She is trying to protect herself from, or a lady is trying to protect herself from abuse. And she is really breaking down in front of the court. Now, the court cannot, be blind to the emotional aspects of it. So, court has to entertain some of these things. And in many cases, forget these family matters, emotional matters. Suppose your land was, you lost your land in, let's say, a dam. For a dam project, your land was lost 25 or 35 years ago. We have a case where in 1975, they've lost their land for a dam. They have been allotted alternate land, which is because it's now it is irrigated land. So they have, whatever, if they had 10 acres of land, now they've been allotted 2 acres of land because 10 acres non-irrigated versus 2 acres irrigated. How this equation came about, forget that. But now they have got 2 acres in an area which is, these 2 acres have been taken up from a local sort of a thug or a strong man from a local area. He is not letting them get access to those 2 acres. This is being 1975, today is 20, and this is 2018 I'm talking about. So you are saying, this many generations have gone. And he's not getting or she's not getting justice. Now, such person comes before a court and they really, emotionally break down. What do you do? The judges cannot really, in heart of hearts, judges also understand this pain. And some of them, they feel that their hands are tied. Some of them feel constrained by law. And sometimes they are outwitted by procedures by the opponent. And in all these cases, they find themselves, fighting against a flood of cases which is coming in. They have to deal with hundreds of matters every day. So that is their problem. So I'm not saying that judges are to blame. What I'm saying is that the system has a flaw. And when the system makes this procedural thing more valuable or more real as compared to substantive relief, then people feel that they've been betrayed by the system. So that is what. That's why, in many cases, you find that, I don't know if you are aware of this, but there was this Anand Dighe from Thane. Okay, he was a local strongman from Shiv Sena.
Yeah, I know.
He used to conduct his own court. Okay, and his court, it's like a strongman's court, and people used to go there because that thing used to get resolved. Now, because there is no procedure, there is no, but justice is substantive. There is real justice. That's why people went to these forums. Now, if you say that this is a forum, then you say this is like Khap Panchayat. And if it's true in one sense. If you let these strongman people run courts, then they will run their own courts. This is not allowed, and this should not be allowed.
Yeah.
But this is because the normal legal system is failing in its duty. And that is more relevant to identify, and that's why this, secondly, these reporters also report in a very, evocative way or provocative way. So they actually, what they do is, they really make it sound as if it's a very big scandal, and they don't report what is really happening before the court. So if they would have been sitting before this judge from morning, they would have they would have heard Justice Bobde being addressed as Your Honor, Your Lordship, My Lord, Sir, anything, and he would not have, been minding. It's just that because he wrote it in order, everyone is piling on to this bandwagon. I mean, I'm sure it is cruel. That is not the point. It is cruel. But, in particular, this case, it might be okay. But this is the reality. Procedural problems have crept in and they have denied the people the substantive law. There is definitely the case.
Yeah, that I agree. But in this particular case, if we talk, so he said that don't use incorrect terms. So how is, Your Honor is also correct, right? The correct way of addressing the court.
I mean, literally speaking, this particular, if you are in that, the judge will rag you for anything. I mean, I went to engineering college and, we were ragged in a sense in so many ways, and they have become our friends. And, I'm sure many people who are listening to this also had some sort of a ragging from their seniors. It is all, I'll tell you one instance, okay. In one case, a junior was appearing in a matter, and I was there. The judge asked, is there a delay? So I said, yes, there is a 5-year delay. So the judge says, 5-year delay? So he asked the opponent advocate, what is your stand? She was new, just passed out of the college, and so completely wrong. She said, I object. So the judge started laughing. So I also started laughing. I told her, don't object. And so the judge said, madam, he is bringing your party on record. You have failed to inform him for the last 5 years that there has been death in one of your party's house, and then his legal heirs have to be brought on record. So it is your party he is bringing him on record. You cannot object. That was the simple premise. Then in another case, this junior appeared before the court and said, "Ki, I am requesting for time." So the judge said, "Ki, on what grounds are you requesting for time?" They said, "Ki, my senior is appearing and he's going to appear and he's not yet available. He's stuck in traffic or something." So, which is a fair thing. So the judge said to this junior that you tell me 5 points in the facts of the case, and I will grant you whatever time you want. But you tell me 5 facts from the case. Okay. So he said, "I don't have papers." So the judge said, "Take the papers." He gave the court's paper to the junior and he said, "You read it, point out or give me 5 facts from the matter, and then I will give you whatever time." So then finally, the junior was not able to, he did said some facts and, some of them were wrong and all. So the judge said, "I will give you any dates. I will give you another option. I will give you any date you want, provided you argue the matter." So the junior was in a fix. The senior was also in a fix. So he said, "I'm not giving you date. You argue the matter." And this is ragging. This is pure ragging. I mean, he's not going to pass an order based on junior's argument that we knew, but it was pure ragging. And this is also part of, because there is also a formal relationship between a judge and a lawyer. And a judge has to train the lawyer, and particularly junior lawyers, to act as an officer of law. And that is very important. So if you are not acting as an officer of law, before you act as an advocate for a party and just, present one side of the case, you should act as an officer of the law. And that's what this training was meant to be, rather than, So sometimes it is valid, other times it's unnecessary, but always it's cruel for the party, particularly in India at this stage. If we had a smooth judicial system, I would have laughed it off. I would have said this is a fun instance where the judge is taking case of the lawyer. In one case, I'll give you another case. The lawyer who was going home, he had removed his band. Okay. In a high court, you're supposed to wear a band along with he was otherwise in proper dress. The band was missing. He was just going home because the court was almost, the time was up. And suddenly his matter was called out and he rushed into the court and he forgot the band. And, he didn't even realize that he is not wearing the band. So court took his case because he was quite senior. He was, he was not a junior advocate. He was not senior advocate, but he was not junior advocate. And the court said, "You are not dressed properly. How can you, address the court in this fashion?" So, court took his case.
I think I remember you sharing this with me, and the court said that I can't see you. I mean, you are not visible to me. Something like that.
Yeah, I think.
And he was like, "How is that possible? I'm in front of you. I'm trying to argue the matter." So the court said, "But I can't see you." Then he realized that the band is missing. So he went outside, took his band,
borrowed a band. That time it was. But that's the procedural part of it. Some of it is acceptable. But this is what happens. Coming to the real issue, the serious issue of that is that procedure is always the handmaiden of justice. That's what the law keeps saying. Now, what does that mean? That means that procedure is just it's a frill. It's something on top of the judicial process. Judicial process and the courts have to make sure that they are giving complete justice, and particularly High Court and Supreme Court, which have exemplary powers in India. They can do justice beyond what the Act is empowering them to do, and they have the power to sort of take into account facts which have not been put on the record, and they can make the parties put those facts on the record, and then they sort of derive that this is the complete justice. This is how the complete justice is required to be done, and that's why I'm changing the nature of this matter and I'm giving you this order. And Dharmadhikari, Justice Dharmadhikari, who retired from Bombay High Court because he was transferred, he had this habit of sort of expanding the locus, and not just the locus but the scope of the petition, and bringing in elements to do complete justice. So that is what he used to do. So that is there. But having said that, so my point is that judges should exercise this power in a complete manner and not just rely on the procedure. Because why this procedure? And this is, we are talking about the court procedure, but in the law there are two parts of any law. One is the substantive part and the procedural part. Now this procedural part is designed to be so cumbersome because it was designed, the nature of procedural law is that it was designed by the British to make sure that Indians are grinded so that they don't get the true justice. That's why it is called the juggernaut of justice. It's too difficult to stop, but it grinds many people. So that's what it is. And the main thing about that procedure is that this procedure in modern law, if you see, achieves the exact opposite of the intent of the law. So if the intent of the law is to give you benefit, I will give you, right to education. Right to education is a fantastic law, which is great example of this. They will give you a right, but the procedure will deny you education. This is the process called governmenting. So the procedure achieves the exact opposite of what the law is intended to achieve. And this is why all the laws which sound very nice when the politicians say it, or in the parliament when you see it, when it comes to you, it becomes onerous. And then you say, I am just suffering more and more. What is wrong? It's because the people who design these procedures, mostly bureaucrats, because the politicians have no clue how to design a procedure. Once this procedure is designed, it is so onerous and troublesome that to get that benefit, you have to give up, many of your rights. And this is what actually has happened even in Aadhaar law, even in many of these laws. So that is the problem that Indian legal system is facing. There is a difference between the letter and the spirit of the law. They are at conflicts. It's not that the letter is not fully compliant with the spirit. They are complete opposite of each other. And that's the problem.
So what are the possible solutions to it? I mean, one which I always keep on saying in many of the discussions or whatever chat I have with my colleagues or friends is technology, the use of technology, which is not used properly by the system, by the stakeholders of this system, advocates, judges, and everyone. And that is one thing which I feel can transform the system to something very different and very, in a better way, which I think it can improve it. Like more than 50 to 60% of the problems will be solved just by using the technology properly. Do you think, like, apart from that, I know that you agree on that, and apart from that, do you think any other solutions are there?
No, indeed, technology is, in fact, will speed up a lot of these processes which are out of the court's purview. Like just if you take simple processes like, giving a notice to a person, that takes so much time. All these processes and, within
let's explain this, because many of the viewers or listeners won't be aware of this. So how is a notice
why don't you explain? Because you have faced this problem many more times than
so I had served, like, kind of helped in serving the notice, where first of all, to issue a notice, the court issues the notice. You have to request the court. You can't, the lawyer does not. So when the matter is going on in a court, you request for a notice due to so and so reason. You have to cite some authentic, proper reasons. And if the judge, and he is satisfied with your argument and the reasons, then he issues a notice to the other party. And then it is not like the notice will go automatically. So the notice is judge just gives an order that notice be served to so and so party. It goes to in that office of the court, of the judge, or whatever department it is. Then you have the lawyer or usually the juniors of that lawyer do the follow up with the department who is going to serve the notice. So you keep on following it up once the notice reaches, I think that person who serves the notice is called something. Bailiff, yeah, bailiff. So usually people don't work as the work is given to them. So you have to make them work, and there are multiple ways how people get it done. so, so you have to keep another follow up with that person, that bailiff. You have to treat him like your friend or some special person, and get that notice served. And sometimes they are also overworked. Okay, so that is another thing. They have a reason to say that this work didn't happen because I have so much other work. That is the reason which they give. Okay, so that is that. But to get that notice served, you have to do all those things. Plus, if it doesn't get served to, you have to personally go with the bailiff to see that he is serving the notice properly, and then the notice is served. So all this is the procedure which is works practically. You can go ahead. What you
so this is the area where this is a very simple area where you can just use WhatsApp notice.
exactly.
Okay. That person you want to serve is sending you good morning, good afternoon, good night WhatsApp. He can definitely be served on WhatsApp, on Happy New Year and all these kinds of weird messages. And we can serve him on WhatsApp or any such platform that is technologically more prudent. And my point is that this kind of process, which is the delivery of notice, and there are many such processes. There are processes which relate to papers of the court. There are many elements where the lawyers can use better technology, the court can use better technology internally, the court can interface with the litigants using technology, and it can become better. And now, in this 2611 case, this David Headley, correct? His name,
yeah.
That's his name, right? So he's being imprisoned by the US authorities, and the judges in India would have a video conference call with David Headley, and his statement was taken based on video call. Why can't this process be taken for everyone?
Yeah.
I mean, what prevents this process being used for every litigant? Why do you want every litigant to travel so many kilometers, come there in the court, say ki what you have got is next date is of 3 weeks? For that matter, he has to spend his whole day coming and appearing before the court. Well, if he doesn't appear before the court, then you say, why is the party not here, and therefore I am giving you 3 weeks time. The party should be here. And that is what happens. And in many cases, the appearance of government officers is required. So government officer is required to be here at 10 o'clock before the court, or 11 o'clock or 2 o'clock. And government officer comes at, he starts very early and he doesn't reach. Okay. Matter is being called out, we are after him. Where are the papers? He is carrying the papers with the file he is missing because he is having lunch somewhere, or he comes in late, or he comes in and wastes his day. In any case, the entire day is gone. So you are wasting government officers' time also. You have called principals, you have called litigants. This whole thing can be avoided by use of technology. And I think technology is a big enabler, and we should definitely look at technology. But at the same time, law and order reform, and particularly within law and order judicial reform, is absolute necessary. There is, it was required probably 10 years or 15 years ago. We are already way overdue for this reform. And our problem, like I have been explaining in variety of videos, is that law and order and right views, and in budding lawyers, even PN views, we have mentioned this time and again. Law and order is the first reform. Without this reform, your new reforms will be defeated by procedure. So make this reform as the core bedrock of every development. Once this is implemented, you will find that further reforms are much easier. The corruption will reduce, the procedural headache, will reduce, and litigants will be truly happy. So, in fact, there are three things that I believe we need. One is to move from letter of the law to the spirit of the law. Move to a principle based law. Because parliamentarians, the elected representatives, are not wise enough to draft the letter of the law. So they accept whatever letter of the law is created by these bureaucrats. If anyways bureaucrats are going to create the letter of the law, not the principle or the spirit of the law. If they are going to you create a broad outline and let the courts interpret the letter. The letter of the law can be left to interpretation. That is one important thing. Because principle based law allows the court much wider leeway in interpreting how this procedure, whether it is helping the person or not. And in India, I am telling you, there are two problems. One, the geography is vast. So, there are wide variety of issues. If you plan for sea, there are problems with rivers. If the law relates to sea or water bodies, then there is one area the problem is of sea water, one area the problem is of rivers, one area the problem is of dam related lakes and reservoirs, other area is saltwater reservoirs. There are umpteen number of problems. You cannot even, then there is marshland, which is, can you classify that as water or can you classify that as land? Because it is marshland, it is not water. Then you are denied benefit. So all these things become problematic. Secondly, there are people in one part of country, you will find that some people are living in 10th century. They are not literate, they don't know, they believe in some other world. They believe that, earth is flat. That is also possible. Okay. On the other end of the area, you will find people who are living in 22nd or 23rd century. They are in robotics. They want everything, they come with an iPad. And they try to see. And their iPad doesn't work. And then they are surprised. My iPad doesn't work. What is happening? Don't go in 22nd century, be in 21st century. We are here. So this creates a problem. You design a good case for Mumbai, the same case fails in Pune. Forget remote parts. Pune, you have some other reality. If you design for Mumbai and Pune, you can't design for Kolhapur. Okay. If you design for Mumbai, Pune, all Maharashtra cities taken care of, then Gujarat cities fail. Then the procedure becomes longer and longer. So this is not a valid concept, particularly for India. I mean, it has some validation, but you have to believe in the principle-based law and you have to explore it. Until and unless we explore it, we cannot realize it. Yeah. Secondly, you have to go back to our Indic system of law. Now, Indic system of law, the Western system is based on rights. Indic system is based on duties. And which means the duties keep changing. Everyone is supposed to follow their duty. And the duty is cast usually on the government officers. Okay. And their duty is written in the letter. So they say, and classic example, okay, they will make you run around for anything, which is very simple. So if you say, government of India has given me 2 lakh rupees, then you will go there, you will find that your 2 lakhs has been withdrawn. You see, how is that possible? I am here, but someone has come and signed for you. So then again litigation starts, because who is that person? Find them. And suppose it's not given to anyone. You go there and they say, first prove that you are yourself. And that you cannot prove just by giving a certificate saying, photo, see my election card, this is me. Because election card photo, if you see, I can't recognize myself. Forget government officer recognizing me. On driving license, on election card, I can't recognize myself.
But I think that is changing now because of Aadhaar card, and you have to keep updating it.
Correct. So this is what technology is enabling.
Yeah.
But what this government is doing is that they are circumventing bureaucracy using technology. And you can't circumvent bureaucracy 100%. Okay. Wherever they get a chance, they will subvert the whole process. So this is what is happening. You have to reform this law and legal part, without which it won't happen. So my suggestion is, look at Indic law. I mean, we don't have to directly jump and tomorrow change the constitution saying from tomorrow Indic law will be applicable. No, you just have some research. Let's go into a duty-based concept of law, where actually government officer also has a duty to serve the people, and not just randomly saying you bring 5 papers. In one case, my friend who was trying to close his deceased mother's account, he went to the bank. The bank said, first you give me a written letter. So he gave a written letter. He gave him 3 forms. He filled out 3 forms and submitted them. They gave him 7 forms. He said, this is like a card game. I am playing 1 card, he is playing 2 cards. He said, what is going on? So he said, no, this is the procedure. There is no escaping the procedure. And then they had an affidavit. Okay. And this is what happens in that procedure. The affidavit said, suppose it's a standardized template affidavit. So it said that I am so and so, resident of so and so. Now here, if he puts US address, he's US citizen. Okay, if he puts US address, they want him to validate it from the US consulate in US. Okay, not in India. But if he writes Indian address, they won't ask. They will just give him the money. Now, what procedure is achieving here? Nothing. But then the procedure is there. So this is what I am saying. The procedure, instead of that, you follow a duty-based law, principle-based law as a first process. A Indic concept of duty-based or a dharma-based law is another concept. And empower the courts to seek complete justice, not just give judgments. There are dime a dozen judgments. Okay, like Justice Sawant used to say, don't tell me all these judgments. There are judgments this side and that side. Don't give me judgments. So tell me you are right. That is true actually. You can give judgments, you can show for anything. But that does not give you complete justice. You focus on the justice, everything will take care. Today, these days, I am finding it difficult to read one judgment, because in that judgment time I will spend on reading a judgment, I can read 3 novels. Because no judgment is less than 100 pages. If it's like Ram Janmabhoomi, it will go 800, 900 pages, and there will be nothing. It will be like a law college exam paper. There is story of Shakespeare in there. There is, Hamlet you will find in there. You will find, stories from Greek mythology, Indian mythology, everything will be there. Other 100 judgments will be there. And at the end, the judgment, the order, the main operative part will be like 3 lines. And it is of no significant value. You can quote anything and support anything from that. As said in, this so and so X versus Y judgment, law is amenable to so and so. Of course, these are all proverbs. You take the book of Proverbs and just copy it. 900 pages straight away. So no use. Give justice. Don't give judgments. That's the 3-step solution, I think. Principle-based law, duty-based assessment, Indic concepts. And third is give justice. Don't give judgments. That's, I think, the predominant solution what we can think of.
Yeah. And this reminds me of a case where I think Justice Gautam Patel had admitted that he had given a wrong judgment before and he corrected it later then. So even
Yes.
such instances happen. Okay, I think on that note, we can end this conversation. Anything else you want to add?
No, I think to summarize, we should look at judicial and legal reforms. That is the predominant message. And I think everyone, whoever finds any forum, any meaningful audience, they should always, canvass for judicial and legal reforms. Once those reforms come in, all other reforms will be simplified.
Yeah, agree. Completely. And that's why we are always stating this thing. in most of our episodes and also in my other podcast, Budding Lawyers. So, if you guys are interested in, if you are studying law or lawyers, young lawyers starting their work right now, you can check out our podcast name, Budding Lawyers. So where I interview and kind of have conversations with lawyers, young lawyers, and even law students, where we discuss on topics like anything like practice maritime law, corporate law, legal technology, etc. Many things. You can check out that, and also we have a YouTube channel in Budding Lawyers. You can check it out. That's it. Thanks for listening to this session.
Thank you.
Bye.